Good morning. You're Raul Carreno, and Mr. Carreno's case is set for trial to begin with jury selection next week. Mr. Matuska, Mr. Nichols did mention to me this morning an issue.
It's with scheduling. The DNA was sent out to a private lab, and they were requested a little more like a month or so ahead of time notice, and I only gave them a few weeks, and they said they wouldn't be able to schedule.
Okay.
So I'm asking for a reset for that.
And that's a private, it's not the normal lab that we use?
It's not DPS, it's a private lab that was used to expedite testing in this case.
Okay. Obviously, we need that, I would think. Okay, so what I'm going to do is I'll reset it to the next trial docket. Obviously, at that point, it'll be time probably to get it done. That'll give you plenty of time to get with them now that we know that issue. And so we'll get that taken care of and get it on the next trial docket.
Yes, ma'am.
Okay, thank you. Go back with the bailiff. Is Mr. Samuel here? Oddone Samuel?
I did see.
Oh. Yes, I'll hold your case. And Mr. Wilkerson, it looks like you've got a tablet out. Are you working on paperwork on Mr. Johnson?
No, Your Honor.
Okay, Romeo Johnson. Morning.
Morning, Judge.
Morning. Good morning. Are you Romeo Johnson?
Yes, ma'am.
And this is cause numbers 24 DCCR 2095 and 2419. Mr. Johnson's cases are set for trial to begin with jury selection next Monday. What is the announcement?
We're ready, Your Honor.
All right. Anything that changed in negotiations that we need to go over today?
I was given some additional discovery materials, but it's just a complete autopsy.
Okay.
There's no new offer or anything for me to present to my
And I'll entertain a counteroffer.
All right. If y'all want to visit this morning, just to double check if there's any counteroffer or anything like that, let me know. I'll hold it for a minute. Otherwise, it'll get numbered for trial.
Yes, Your Honor.
Okay. Thanks. Mr. Galmore, you've got Ronnie Green.
Good morning.
Good morning. Good. How are you?
Pretty good.
Let's see here. And this is for, you're requesting bonds on the two motion cases,
Yes.
correct?
He's on deferred on two different cases.
There's also additional fees.
Thank you. I'll pull that up now, Mr.
I'm just really asking for a setting on those additional files.
Okay. Oh, okay. Okay. Good morning. Are you Ronnie Green the third? And Mr. Green, we have 23 DCCR 1502 and 24 DCCR 1320. Mr. Green is on probation for possession of a prohibited weapon and possession of marijuana. Motion to revoke probations have been filed in those two cases. There's a new indictment in cause number 25 DCCR 0735. Mr. Green is charged with money laundering. Mr. Galmore has filed writs asking that I set bonds in those two MTRP cases. He is on deferred probation, so generally entitled to a bond, but based on the nature of those offenses and that new offense, I wanted to have a hearing and get the state's input on their position on bond amounts, and bond conditions.
The state's filed a reply to the writ that was filed by Mr. Gilmore. I don't know if you had an opportunity to see that or review. I've kind of laid out the state's argument
Okay,
in that reply.
let me look at it
I'm happy
real
to
quick.
recap it.
I feel like I might have seen it, but I've slept since then, so give me a second to.
Judge, I don't know if you see letters in there as well. There's been letters that have been supplied to the court.
Okay, I'll take a look at all of that. I don't know. Do I have any of that over there? Anything printed out on him? Some of that sounded familiar. Yes, okay, so I saw the letters.
Yeah.
I can summarize this for you, Judge.
Okay, the letters I got printed. Let me look at this real quick. Now this is looking familiar as well. So yeah. And I recall now what you filed also with regard to some requests, and we'll get that set for the appropriate time, Mr. Coleman, as far as modifying bond conditions and things like that. And I guess you've seen those.
Absolutely.
I don't know if y'all want to talk about that, if there's some agreement or not, but for this morning, Mr. Galmore, I guess you can just make argument or...
Yes, Judge. I would just like to summarize a few things real quick. He is on probation for 2 cases. They are different offense dates, but I want to point out that he did not receive probation and then pick up a new case. These were the situation where he received probation and there was an older case that just simply not been filed yet. Since he's been on probation, there has not been the commission of any new offenses other than the offenses we're talking about today. I will say that he's been in jail for 20 days, which is longer than any other time that he's ever been arrested before. I did have discussions with the state today about a possible resolution that would involve Mr. Green going to ISF and not revoking his probation. And that sounds like a reasonable outcome. I have not had an opportunity to review the discovery in the new case, and so I don't feel like I'm in a position yet to advise my client on what would be the best option as far as that's concerned. I would point out that in the letters, there's one thing that really kind of struck a chord with me, is that since this alleged offense of the money laundering, which was earlier this year, Mr. Green has really taken a lot of efforts in his life to start walking the correct path. He became more involved in his church. He was baptized since the alleged commission of this offense. He's got a lot of family support. His mother is here in court today on his behalf. And so what we're just simply asking the court to do is set reasonable bonds. He is on deferred. And even though there is a new offense, I would say that the majority of all motions to revoke probations are based on illegal activity. Even if it's not a new offense that was committed, it's alleged. Very common is a failed drug test, and obviously if you're failing a drug test, you're committing a crime at some point, possessing that illegal drug. And so we're just simply asking the court to set reasonable bonds. I believe reasonable bonds in this scenario would be about $10,000 on each case. I believe the government is asking for $50,000 in their motion.
Your Honor, and Mr. Galmore and I agree that we are both asking the court to set reasonable bonds. My version of what's reasonable, given the fact that less than 1 year since the defendant was placed on 2 deferred adjudications, he's out allegedly committing money laundering. If the allegations are proven true that money laundering, those proceeds constitute proceeds from drug trafficking or delivering controlled substances, Judge, the opportunity, as Mr. Galmore put it, to walk the right path, the correct path, came back in 2024 when this court put him on probation for possessing a weapon that was outfitted with Glock switch. My version of what a reasonable bond should be in light of this defendant's actions is no less than $50,000 in each case, Judge.
So if there is well, 2 things with regard to what you're talking about. One is, depending on whether or not the allegations were proven true, and if there was some thought of continuing Mr. Green on his probations and getting a probation on that new case, the only way I would go along with something like that would be for ISF, some type of cognitive program in custody. And while I understand and appreciate that he's making some strides on his own, from a legal standpoint, it doesn't make a whole lot of sense for him to be back out and then go right back in to ISF. The point of ISF is to get that done so that when you get out, you've got better tools to make better decisions so that you don't end up in prison for, I mean, you're looking at prison up to 10 years on those two cases, and then you've got the new money laundering case. So
To address that, just real quick, Judge, the money laundering case, I've only been on the case for approximately 2 weeks.
right.
I've been speaking with Mr. Green. He states that he does have proof for a lot of the money, so I don't think at this point I can even advise him that agreeing to a deal where he goes ISF when that's the only violation is the appropriate route. Of course, with him being in jail, it's a lot harder for him to assist in his own defense of that case.
And Judge, of course, the state has a different position on the proceeds or where those funds were derived from and our ability to prove where they came.
Let me look at something real quick. I guess. I'm just taking a look at the probable cause affidavit on the money laundering, just to get an idea of what those facts are. I think I have a little bit of them from the facts, obviously, from Mr. Coleman's response to your request, but let me look at this real quick. Actually, I can't read it. I'm printing something. Maybe.
Maybe.
It's a long way for it to go from here to there. Okay, how long, obviously you need some time, Mr. Galmore, but how quickly could you get up to speed on the money laundering?
It wouldn't take me very long to get up to speed on the discovery and watching the videos, but it'd be substantially more difficult to try to track down financial records for Mr. Green while he's incarcerated in the Jefferson County Jail, which is one of the reasons why we're asking for bonds, so that he can assist in that part of his defense.
Your Honor, I would offer this. When interviewed by the law enforcement, the defendant indicated that he had no records that would show the source of the proceeds that were received.
That you're correct, that's what I see as well, other than maybe one social media post on Instagram.
it appears on the roadside discussions about the sources of money that Mr. Green did not have a lot of answers necessarily, but I would say that on the side of the road, and the question about.
Well, I think they brought him in and Mirandized him, right? Once at the jail, read Miranda warnings, waived his rights, and during the interview, couldn't explain how he obtained it, advised he sold one French bulldog late last year for $1,500, but nothing else. Didn't have a job. One Cash App thing he could show for that one dog. So,
I haven't seen that video yet. I'm assuming it's video recorded, it's supposed to.
it should be, yeah.
I just haven't had an opportunity to review that video. I do know that there was a car wreck where he received a settlement from that car wreck, so there were some additional funds that weren't discussed. But again, I don't have access to those records as of yet.
Okay. All right, so what I'm going to do is grant the relief requested in 23-1502, set the bond in that case at $35,000. In 24 DCCR 1320, also set the bond at $35,000 in that case. I'm going to order as a condition of both of those cases that Mr. Green remain in Jefferson County, also that he wear a GPS monitoring device at all times, and then we will reset the case for a status at just in normal 30 days or so. Okay?
The court believe or think that a curfew would also be appropriate?
He's on probation, so he has a curfew.
All the standard conditions.
All the standard, you're still on probation, so if you make these bonds, all your regular conditions apply, but now there's the GPS monitoring device and a remain in Jefferson County also as a condition of your bond, not just your probation. Okay? All right.
Thank you, Judge.
Yes, sir.
Judge, can I approach very briefly on?
Give me just a second. I don't know if I need all that, but that's all his stuff. Yes, sir? On Romeo Johnson?
He doesn't want to make a counteroffer,
Okay.
so I was just letting the court know.
All
I
right.
do know, kind of need to know, I guess I'll find out after it's numbered, what case we're going on. Yeah.
Well, let's figure that out. So it's going to get numbered. And so which case would be, Mr. Coleman? Which case would the state intend on going on?
The murder, Judge.
Okay, so 24 DCCR 2419 will get numbered. Thank you. What? Yeah, because I'll number them, and then in a little bit, I might get one of y'all to help me send out the trial order. So yeah, she didn't reset any of those yet. Yes, ma'am, thank you. What you need? Mr. Rojas, you have Christian Kane. Good morning.
He's competent, we'll do the competency first things.
Thank you. Let me see. Good morning. Are you Christian Kane?
Yes, ma'am.
Okay. We're going to lesser.
Yes, Your Honor.
This is cause number 24, DCCR 1947. I am going to take judicial notice of the court's file, including Mr. Kane was previously found not competent to stand trial, sent to the John Dunn Behavioral Science Center for Competency Restoration, received a packet from them dated September 15th of 2025. It includes the attending physician's report to the court from...
This is the exact moment where everything changes. The judge isn't focusing only on the original charges anymore. She's looking at Christopher's actions while in custody. 21 disciplinary reports in just a few months tell a troubling story. Fights with other inmates, disrespect toward correctional officers, stealing food, and repeatedly refusing to follow jail rules. From a legal perspective, probation is based on trust. The court must believe that a defendant can follow the law while living in the community. If someone cannot obey the rules inside a controlled jail environment, convincing a judge to grant probation becomes extremely difficult. That's why these...
Dr. Liberis, with the opinion that he is currently competent to stand trial. In addition, there's a trial competency evaluation report that was prepared by Dr. Robinson. Also has the opinion in that Mr. Kane is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor.
No, Your Honor.
All right, then at this time, based on the two reports, I am going to find that Mr. Kane is competent to stand trial. Mr. Rojas, will he waive the formal reading of the indictment?
He will, Your Honor.
Mr. Kane, in cause number 24 DCCR 1947, the state's elected to proceed on the lesser included offense of a Class A misdemeanor evading detention, and that's from August 9th of 2024. And how do you plead to that charge?
Guilty.
Okay, and are you pleading guilty freely and voluntarily?
Yes, sir.
And because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, I did.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection.
It's admitted. All right, Mr. Kane, I'm going to find again that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of a Class A misdemeanor evading detention. Sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff.
Because obviously got added to the.
See, Marco Gomez, Mr. Rojas.
Judge, I don't know that we need him, Judge. His family's looking to hire him an attorney.
Okay,
Same thing with Mr. Hawkins. Mr. Hawkins' family's already talked to somebody. They're going to hire him this week, he's been told.
okay. So we'll reset Mr. Gomez, and if you'll make a notation that his family wants to hire attorney. And who was the other one? Mr. Hawkins?
Calvin Hawkins.
We'll reset Mr. Hawkins as well, same notation, please. And, let's see. Lucius LaFleur, Mr. Rojas? Are you working on Hendricks?
Tommy's got it. It's an add-on, so he needs his file to see what make sure the offer's right.
Oh,
But they're all going to be, everything else should be approved. I'll email the attachment.
thank you.
What happened?
You said charge him off,
It's not, 30 days in jail.
I don't have that. Let's hold on. Or you can correct the time where
I'm okay.
okay.
Good morning. Are you Lucius LaFleur?
Yes, ma'am.
And will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. LaFleur, in cause number 20-33730, I have a motion to revoke your community supervision. This shows that you were placed on probation November 3rd of 2021 for the third-degree felony offense of theft of material, and that was a 7-year term in prison that was probated for 10 years. Is that correct?
Sure.
And the motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of a Class A misdemeanor assault September 11th of 2023 in Angelina County, Texas. And is that true or not true?
True.
Count 2 alleges that you committed the offense of possession of a controlled substance January 23rd of 2024 in Angelina County, Texas. And is that true or not true?
True.
Count 3 alleges that you failed to report to the Jefferson County Probation Department by mail or online for the months of April, May, June, July, August, September, October, November, and December of 2023 and January of 2024. And is that true or not true?
True.
And you guys have an agreement, right? Do I need to keep going, Mr. Coleman?
That's what I was looking for. The state will waive the remaining counts.
All right, so stay will abandon 4 through 6. Mr. LaFleur, did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
True.
And did you plead true to those counts because they're actually true?
True.
I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas?
True. Yes, it is.
Thank you. And do you fully understand them?
Yes, I did.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
True.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. LaFleur is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation and reassess your punishment in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm trying to print, and it's just... I'm going to hand you the trial court certification that shows this was an agreement, so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because your probation you've been on it for a while, I'm not sure that you got this when you initially got on probation. But because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could
By
lead
the
to
end of this hearing, Judge Raquel West made one message absolutely clear. A second chance must be earned through actions, not words. Christopher Bushnell's repeated misconduct inside the jail convinced the court that he was not ready for the responsibility that comes with probation. As a result, the plea agreement was rejected, the case was placed on the trial docket, and he now faces the possibility of a much harsher sentence if convicted. This case highlights an important principle of the criminal justice system. Rehabilitation requires consistent accountability, and every decision a defendant makes while awaiting trial can influence the court's final judgment. Now we'd like to hear from you. Did the judge make the right decision? Or should Christopher have been given one last
or
opportunity?
ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff.